Oh, this is it? Oh, okay. And are we on? Are we starting? Okay. All right. Good morning, everybody, and welcome to the first Defence Innovation Network and United States Commercial Service event that we're kicking off, where the DIN and the US Commercial Service, which is a part of the US Department of Commerce, are moving much closer together and forming partnerships where it makes sense to help our companies and our researchers and our spin-outs access the US market, venture capital, and certainly understanding the issues surrounding IP, which is why we have organised this event today with the Dr. Richard Thurston, which will come on. I'll introduce him in about 5 minutes. To give you, of those that may not know DIN, a little brief overview of who we are. Defence Innovation Network is a membership of 9 research leading universities across New South Wales and the Australian Capital Territory. We are primarily funded by the New South Wales Government via the Office of the Chief Scientist and Engineer, and we also receive some funding from the Australian Department of Defence. Now, what we do is we go out to our Department of Defence and we seek the most pressing emerging issues and problem statements, and then we go out and solve those and fund about 6 grants per year. To date, we have funded about 25 to 30 grants over our lifetime. To give you a little bit of an idea of what we focus on, we have funded projects from everything to the, sorry, I didn't hear that. From everything from undersea warfare, communications. We have 2 neuromorphic event-based cameras up on the International Space Station. We funded the world's first quantum magnetometer for positioning, navigation, and timing in GPS-denied environments, to everything including information warfare software. So we're very pleased to be joining in a partnership like this with the United States Commercial Service, and we hope that that is very fruitful as we move forward with our startups and small businesses across New South Wales. Today, we'll be hearing directly from the former General Counsel to TSMC, that is the Taiwan Semiconductor Manufacturing Corporation, Dr. Dick Thurston. Now, Dick is an expert in all things intellectual property. He's also very much involved in M&A and venture capital funding. Dick is now back in the United States, and we thank Dick for spending his Sunday evening in the United States to address us today. So with that, I will hand over to Dr. Dick Thurston. G'day, Dick. Just turn off you're on mute.
Okay, now you hear me?
Yep.
Okay, thanks. Thank you. I really appreciate it. Good morning, everyone. Really pleased to participate in this program. I've been, very much involved with Department of Commerce and the gentlemen and ladies on this call and many other opportunities. So they're a great, partner, and really, I have to say, know how to get a lot of things done. So I always look forward to working closely with them, and now with the Defense Institute Innovation Network, which I'm happy to meet. So today we're going to look at intellectual property, not in any depth, but also look at it from your perspectives, at least what I've understood to be, that perspective. I do a lot of that sort of work today with other countries, other businesses, including the U.S. So if you go to the next slide, it sets forth kind of the framework. So next slide, please. So why this talk matters, I think, as you look at it from your networking and capabilities, there are gaps out there in the innovation cycle. The Silicon Valley of death and related elements exist all around the world. It's not just something for the U.S. and Silicon Valley. It's a valley of death, quite honestly. And more importantly, and I think what we'll spend more time on, is looking at the lab to fab conundrum in which I'm very actively involved. IP as a topic, it's very broad, sometimes too broad, cuts across many different disciplines. Some of what we'll talk about or skirt or by today in different aspects are your success. And as I advise early stage companies, SMEs for really over 40 years, these are some of the key elements that I find repeating themselves. One, you need to have a clear strategic IP, and data rights has become even more importantly relevant, particularly in light of AI, which really underlies so much of what we'll be talking about. Contract clauses get many people into trouble, and that's where they're often not balanced, and IP is often given away uh, innocently, unknowingly. Export control has become increasingly a challenge. We're not going to address this today, this element. I believe that our friends at the commercial service are going to do some program later on ITAR and related topics. The accessibility where I find, many U.S. venture capitalists asking is what is the accessibility in bridging the gap between lab to fab. And then last but by no means least important is what is your governance structure and how is it integrated with everything you do, and particularly your portfolio management. So I view IP as both a shield and as an engine of growth. Next slide, please. When we're looking at on this next slide, it's how do you gain and how do you lose value? And in fact, most of these elements here, you can both gain it by the proper structure or you can lose it by the improper structure. So when I've been working with a lot of defense related and particularly dual use technologies here in the US, Europe, Asia, I've never gotten involved with anything in Australia and New Zealand, but pretty much the same, I think. The ideas, of course, start very much with collaboration, and through your network, academic industry research and collaboration is extremely important. It is for basically all high-tech companies. At TI, Texas Instruments, where I was assistant general counsel for many years, and then TSMC, where I was general counsel and senior vice president reporting to Morris John. We had to constantly deal with this challenge of, yes, working with and building ideas, but making sure we did not, lose the core of our technology proposition. As I understand the structure, I won't go into it. There are several important elements that IP plays a role, whether it's DIN, ASCA, ADF. And I think that throughout those different layers and different levels of involvement that you will have, the proper IP portfolio and structure will create the opportunity for you to scale beyond TRL4. There are other factors that impact whether or not you can get beyond TRL4, and however, IP tends to be very much there. So on the right column, as I mentioned, it's how you draft your collaboration IP agreements, and that's with industry and government alike, academia. And in large part, you need to look several steps ahead and several years ahead as to what is your business strategy? What is your technology roadmap? What is your product roadmap? And are you going to be able to achieve that or those roadmaps because you have not conceded too much in the way of intellectual property? And this is a very detailed, in-depth topic, that is also in itself, I think, appropriate for a separate program, quite honestly. What is your IP strategy in the sense of creation and filing? As I think all of you are probably aware, there are multiple facets in the IP world. Patents tend to be more focused on, trade secrets are more, ignored. And how does do those two intersect? What is the relationship between trade secrets and patents? And that we spend a lot of time on big tech. TSMC, TI spent a tremendous amount of time on the strategic aspects of it. And that's very important too, because you need to know what are you going to do, how important is the technology, and how's it to be treated, because a lot of people in the industry want to publish, and oftentimes are they publishing before the patent filing, or making sure that the publication or the conference paper doesn't give away any trade secrets. License terms tend to be a very troubling aspect sometimes with the government agencies. I think those can be negotiated and should be negotiated. And I think in this day and age, we end up spend a lot more time in helping companies in this area as well. Commercial rights, of course, you want to make sure that your product, roadmap, is such that you are able to scale up your production, and that means scaling up your investment. So, if you don't do it properly, you can also lose significant value in your company. Now, the big challenge is that prototype stage, the small batch manufacturing. I have a company that I've been creating that is almost exclusively focused on this. A huge area, and particularly in the lab to fab conundrum. And so, how do you make sure that you can get the right prototype development, the right packaging, the right scale up, for your product, and all those aspects that I've just discussed, are very much on the minds of American investors. I've been talking almost every week with dozens of investors, whether they're small or large, whether they're private funds or family funds. And they want to know, how secure is the IP? Is it something that if you start building, someone's going to come after you? And what contamination may exist? And that's particularly true where a lot of people tend to be using more open source, and of course, unfortunately, in many ways, more AI concepts, and that is fraught with a lot of potential for contamination, which may mean your intellectual property rights and your commercial rights aren't what they seem. And again, a lot of this happens early, and often innocently, in an unknown, sense. Next slide, please. So as you're looking at what are your pillars, what are your core elements? As I mentioned, there are a number of intellectual property facets. The two most important from the innovation point of view tend to be the patents and trade secrets. When I joined TSMC in 2001, they were filing almost everything they invented, filing for patents. And I changed that and tore that down and developed a best-in-class trade secret program that focused on many different elements. And in fact, is one of the reasons why TSMC is the power that it is today. It has a well-balanced program on trade secret protection, integrated very well with its patent strategy. Software, data rights, as you see in the right column, are increasingly focused on, and investors are not just asking about your patents. We're not just asking about, do you have a trade secret policy program, and how does that interact with your patent program? But more importantly, they're looking at the data that you get, and particularly I see a lot of this arise as I'm talking with some of the DARPA groups here with the defense research, with actually some of the microelectronics commons programs, those all captured by these data rights concepts that I have. And if you lose your data rights, then you may well lose your rights to the future product or roadmap that you have. So, you want to make sure that as you develop your business and you grow it, you do have a number of checklists that you can resort to make sure that you are capturing most. You won't capture perhaps everything, but at least the most critical elements as you're proceeding and going forward. And so, when you're talking with investors and people that may be interested also in partnering, it could be a joint venture, could be different aspects. There are a number of things that you know they're going to look for, and that what you want to watch out for. So on the next slide, if you turn to the next slide, please. I always have looked at in the left column, what are the nature of the various elements of a government and even university relationship. In other words, for example, how broad or how irrevocable might the licenses be, or what rights, also what grantbacks, might you have to give. All of these are going to be elements that you do have to acknowledge very often, but you want to make sure that it's not so restrictive that you cannot grow your business out in the future. Joint IP often becomes an issue. What does joint mean? Who owns what? Who has what rights, to the IP? And then in the joint ownership context, if there is a joint ownership, then what is it that the other party can do with that, and can they become a competitor to you ultimately? Again, this is important for you and your executive team, but also the financial investors are going to look very closely at what are the encumbrances on the IP portfolio, and what are going to be any ability to get into your future growth and improvements, even if it's not related to the original technology or the original innovation that might have been jointly, developed going forward. So, yeah, contractors are similar. You have to be very careful, again, with the rights, duties, obligations that are granted. And as I note in the highlight yellow part, you grant only what is required for your integration with them, for your development with them, and make sure that you're not creating a future competitor by any means. And a lot of these elements, certainly in the future programs, we can go into more detail, or I'm happy to take any questions offline out into the future. So you're always wanting to make sure that in your preparatory work, as you're creating the business and you've gotten some grants, you've gotten some funding, that you're basically investor ready. And so my next slide, I talk about and start talking about really from the U.S. perspective, because it's my understanding that many, if not all of you, are interested in the U.S. Market. It's a very critical market going forward, always has been, and particularly for dual use technologies as we continue to see the challenges in global affairs. So the diligence that an investor will have will be quite significant. You have to be well prepared, in approaching financial folks. They're Some of them may know nothing about your business, but most of them will be financially sophisticated. They know what to look for in intellectual property and contracts, and they're going to really want to know about your team as well. So I've jotted here some key elements. What is your IP strength? Both now and then your roadmap becomes important. You don't want to give away trade secrets, but you certainly want to show with some clarity both now and going out in the future. A very important element that is often overlooked is, do you have clear title? Do you have a clear change, a control of custody of the intellectual property? Why I say that is you may have employees coming from different circles, different even companies, different institutions. Of course, universities. What are the university rights? Does somebody have a non-compete agreement? We'll talk a little bit more about that. But how good can you defend your IP as being yours, as being, 100% yours, not contaminated across the board? And this is more than just your filings. As you know, in patent, your offices around the world, if you fraudulently file, that means if you don't have a lot of things under the statutes addressed, but for example, you have the wrong inventor, identified, either the name is had nothing to do with it, or that person may be contaminated from a previous employment, and the previous employer may have some rights with respect to your IP. So all that needs to be cleared, understood. For the bigger companies like TSMC, you're even seeing right now they're having some challenges in their uh, uh, you know executives as they leave and even as they bring people on. When I created a very strong program that started with reviewing the incoming employees' background, making sure they did not have any agreements that might be restrictive, or whether or not it's IP related or non-compete agreements. A lot of jurisdictions do not allow non-competes, but there are ways that you can address that. So that defensibility becomes very important as people kick the tires. Of course, do you have a clear corporate structure? What's your roadmap? What's your capital structure? And that becomes relevant because they want to make sure that it's a solid company, maybe small, that's not a problem. But as long as your corporate structure, your governance structure are all in solid position, then that will help address a lot of concerns that they have as a general rule. And you have to think clearly about, once you are entering or you're planning to enter the US market, or any foreign market for that matter, what how's the IP going to be treated? How does it get into that US corporate entity? What does IP assignment look like going back to the parent? What are your licenses? There's a whole slew of items that you have to check off the box, and these you want to be somewhat prepared as you enter discussions with the potential investor or investors. And that will vary, based on their nature, based on their experience. Are they a hedge fund, or are they some other financial institution, or are they wealthy, family, and a family fund that you're dealing with? And then, of course, you're going to be asked today, because of the challenges we're facing in the U.S., but also around the globe. What are the immigration issues, if any? Are you going to have to bring over to the U.S. Any of your folks, and are they going to be able to get visas? How do you work that? Of course, the Commerce Department and our friends on the call here are very good at helping with that and sharing with you the particular issues that may very well exist in this day and age. But you're not going to necessarily find all the talent here in the United States. Team quality can never say enough about how good is your team, how solid is the quality. They don't have to be perfect by any means, but is there the ability, the capability to really achieve the technology roadmap and the product roadmap? If there are some gaps, then you need to show that you understand them and you have a plan to address those gaps. And one of them could be coming to the United States, for your investment opportunity. So, those elements are going to be very important. There's quantitative and there's qualitative elements. Being able to articulate what your team will look like. You may not have identified all the people, but at least you know what is needed to succeed in your business as you are in Australia or in the United States. So always be prepared for a lot of questions and be able to articulate answers. Of course, if you don't have an answer yet, you say, no, I'm sorry, we don't have that solved. We're looking for it. And sometimes the investor may be able to help themselves. So you open that up. Next bullet, as I said earlier, we're not going to discuss any export control or regulatory compliance types of issues today. There are many of them, and this, is increasingly relevant when you come to dual-use technologies, and particularly with respect to certain export, re-export to some of the questionable, countries and questionable economies. Of course, China, North Korea, we're well aware of the growing web that exists, which makes it a challenge for all of you to understand, that with any degree of certainty, because it's constantly shifting grounds. So that being said, you don't worry about it. There's plenty of experts, plenty of specialists, both outside and within U.S. government that can provide assessment. And a commercial team, from the U.S. consulate is certainly more than able to help in that regard. Roadmaps. I keep emphasizing roadmaps, and I've talked mostly about product roadmaps. What is your plan? What is your milestones? Or how are you going to achieve that end product or multiple products? Technology roadmaps. There's a bunch of different ways that you can, peel the onion and address core concerns. But what is your roadmap to scalable revenue? You may have a product roadmap, but how can it make money? How's it going to succeed? How's it going to be able to be competitive in the marketplace? Of course, as I said earlier, intellectual property tends to be a key element of that, and many people, many investors are always looking at that element of what is your IP and how defensible is that IP. We won't really spend any time either on exit options, but you're going to be asked. They want to know, how do you plan to take it to the next level, to enable a number of the investors to exit, with profitability in mind? Are you looking at a sale? Are you looking at a joint venture? Are you looking at an IPO or some other program? There's multiple corporate options that can exist, and your advisors can certainly tell you. And as I mentioned before, do you have any encumbrances on your technology, on your products, even on your people, and whether or not that's government or academic or maybe industry as you look at it? But in many ways, I structure this for my non-U.S. clients and say, look, your IP is your visa into U.S. markets. It's a very important element that can not be lightly taken, for granted. In fact, you need to be looking at that quite carefully. Next slide is focusing on some similar items, but also others that are very important in addressing what could be viewed as inadequacies or even failures of your company. And so I highlight these. First and foremost, I've spent much of my career on, non-disclosure agreements, which are related to trade secrets. And as I've taught courses around the world in different law schools and business schools, I always stress that the most important document you can sign, especially early on, is a non-disclosure agreement. That sets forth how important you view your technologies. It becomes extremely relevant in any courts, even license disputes. It's important whether or not it's an individual, it's an agency, it's an investor, although a lot of investors don't like to sign them, and therefore your initial exchange of proprietary information should not be technical. It's probably more in business. And if you don't have a non-disclosure, that can be very critical to your future and particularly defensibility of IP. If you do, you need to make sure that it's carefully drafted. Where a lot of technology companies make a mistake is that uh, the term of confidentiality is too short. Often you'll see 3 years, 5 years. If your technology is going to have a life well beyond that period of time, you need to make sure that the confidentiality period is well beyond 5, 10 years. I've always stressed as perpetual as you can in that term. And it's interesting because it comes back at you when we TSMC, when I was suing SMIC in China, we determined that we had done a study and that, the core technology that they misappropriated, it was 0.18 micron semiconductor process technology. And the courts found that it was 100% stolen from us. By the time we traced it down to 60 nanometer, 60 nanometer still had 10% of that 0.18 micron trade secrets associated with it. So that learning curve, the continuity with respect to processes becomes very important, and the ongoing use of certain trade secrets becomes very critical. And increasingly your ability not just to have an agreement, but also to properly uh, reflect, the elements in which you control that protection becomes more and more important. A lot of companies do not have, they might file patents, but they don't have policies and procedures relating to IP, relating to innovation. And you can do that relatively simply, starting as a small company. It could even be part of your ethics policy, but it does become increasingly important as you look at investment, particularly larger amounts of money, if your business model is based on technology, which is based, of course, on your intellectual property. So you need to make sure that you have good IP policies. They don't have to cover the world, so to speak, and said that they all I's are dotted, all T's are crossed. But the more you can have some strong provisions and some guidance for your employees, for your partners, then the more important that becomes. So this is especially true if you have no or limited, and certainly no um, ongoing follow through and protection for trade secrets. A trade secret policy is absolutely necessary for virtually every company I've advised over the years, including restaurants. And that, there's a secret sauce, right? So what is it and how do you best protect that and how do you best document that going forward? And it's not just documentation, but it's the recording. It's keeping a record. TSMC, we NTI, in fact, we had extensive records. I'm involved with an NGO out of Hong Kong, which has a program called IKR. Uh, and that's our knowledge registry. And this IIPCC is focused on how do you protect intellectual property, but particularly trade secrets. So it's something that, we can, that is very much open to participation and sharing how that can be done. Not filing patents early enough doesn't mean you have to patent everything, but making sure that you're looking at and trying to create out of your technology what I call some golden patents. All you need is one, but certainly your investors will be looking at that. And make sure in your patent applications you don't disclose too much. There's statutory requirements, but we found at TSMC, which is a process company, for every patent we filed, there are anywhere from 10 to 100 or more trade secrets that were backing that patent, that invention that we did not file and disclose. So that becomes very relevant. Again, I mentioned don't sign overly broad licenses that give certain rights to your intellectual property, to your technology, unknowingly, unwittingly going in the future. And then last but not least, and I alluded to this earlier, making sure that your employees are, of course, treated fairly, but also that they can't just, when they leave your employment, and many employees will always leave, that they can't just go and take your technology to their next employer. So all of this and many other features is and are addressable early on. And I think that's that corporate discipline that is good, big or small. I've used the same thing for small 2, 3 people startups to, of course, a company like Texas Instruments or TSMC. So don't be scared by, the potential, integration of that. I think it's going to be critical as you look at what your roadmap is to build in these different elements into that roadmap because when you're starting off and then as you want to advance your finances, not only is the investor or are the investors going to look at you in your early history, but they want to see how you'll recall what I said is scalability, how you can scale that business and scale it efficiently, effectively, while addressing, the challenges out there, which, of course, in the area of dual use technology, you do have to have a number of more layers of organization, perhaps an individual's responsibility, than what you need, and may have even needed in the past. I spend a large amount of time advising clients in this area of export controls and the uh, global nature of the business, and particularly with potential dual use, means that you have to create, a good structure, from top down and down up, to the top. So that means that again, back to policies, it's going to start with basically your ethics policy, your business ethics, what is it that you can and cannot do, going forward. So I think that as you focus on your business, it becomes customized. You can read a lot in the books, the treatises, the journals out there, A lot of people have their different ideas, but I think at the core of it, it comes back to how defensible is your technology, is your intellectual property in going forward to your really your roadmap. How are you able to achieve that? I mentioned at the outset, and I want to share this with you because it's uh, my experiences recently with also fundraising, but in how to help startups becomes more and more pressing because you look at what is going on in the semiconductor industry and AI. It's much to do about intellectual property that goes and takes you from day one, to future growth. So if you look at the next, couple of slides, I'll talk about on the next slide what I'm doing to help early stage, companies based on all my experience. And then, after I'm done talking about this, we'll be able to open up, for questions, allowing more time. Hopefully, it sparks some questions for you. But where I see the biggest challenge today for the startups, the universities that I'm working with, particularly in the Hudson Valley region of the United States, is how do they get their product concept into prototype and then to small batch, and particularly when you're dealing with defense and dual use related technologies, you're not necessarily in a position or needed to produce a million devices, let's say, in the semiconductor area. So, how do you align with your prototyping, small batch? This is where there's a lot that's been going on in the U.S. and is a good reason to be here. My former employer, TSMC, yeah, it takes months, maybe 6 months to get a prototype to. It costs hundreds of thousands of dollars if they want to do that, and particularly if, from a dual use point of view, that can be done. So, as you look at investors increasingly, and particularly, I had a discussion yesterday with two representatives of two family trusts. These are wealthy individual, trusts, and it much of it where their excitement comes, and everybody seems to be caring is about it is, do you have an AI twist to it? Can you build some relationship in the AI? Almost anything else is being ignored, unfortunately. But how quickly can you transition, production ready devices? That is very important to look at. And can you do it in such a way that addresses the other issues that I've identified earlier? And I believe there is a way, and what we're doing through our platforms is just that sort of aspect of it, and particularly in looking at satisfying both defense standards as well as commercial standards. So I won't go into the rest of this slide. It's just some of the elements that we are offering in our customers. The next slide again addresses IP, and that's IP compliance and trusted pathways for U.S. adoption. And this is again, in fact, yesterday was asked really the same sort of questions here. How can you assure that you retain your intellectual property? How can you make sure that your customers are satisfied because are you going to allow them on the fab floor or not? The concepts of creating scalable prototypes that you can qualify quickly for in the United States or elsewhere becomes even more relevant, particularly in this fast changing world where AI underlies, virtually every defense system, drone system. We're doing work with drones. So you need to make that understandable as to your supplier, your partners, and you have to go through that due diligence of is it a trusted dual use supplier? Does it have secure manufacturing routes? How does it handle the cyclicality in the semiconductor industry and other microelectronics industry? So there's a whole range of issues that are fast emerging in the United States by investors. There's a lot of money out there, a lot of wealthy individuals, a lot of funds, a lot of former semiconductor and other and defense industry execs, but they're slower to invest until they can get some real positive feelings, about the security, the trust, the dependability of that investment. Some may be, wanting to get out earlier, but others may be in the long term. So I know I've covered a lot of ground. I was asked to kind of give a high level, view of where I see it, and particularly as related to the U.S. market. I can tell you that it's a lot we've had, particularly working with U.S. Commercial Service and the various consulates around the world, a lot of success in getting non-U.S. companies here to invest and become quite successful at that with that investment. So I'm going to stop here. I've been rambling on, for a while. I'll stop, and if you have any questions, I know that also Lee Harold has some presentation that he wants to present as well.
Well,
Lee,
thanks very
it's
much.
yours.
Yeah, g'day. Yeah, thanks very much, Dick. That was an amazing presentation that you provided, especially useful to our SMEs, our startups, and especially those researchers that are looking to spin out a startup from our universities and our funded research, especially in the defense and national security space, where the United States market is most relevant to what we're doing here in Australia as our pretty much our only treaty ally, and a very large and important market. So I think what we'll do before Lee from United States Commercial Service comes on is we might just get some questions for you, Dick.
Sure.
So let's see if this works. Okay. Does this work? I can't hear this. Hello? Oh, there we go. Okay.
Hi, Dick. Thank you for that.
Sure.
You talked a bit about employee agreements and I guess some vetting employees prior to them joining. What does that look like in practice? I mean, should we be asking for previous employment agreements and reviewing them, or like how does that work in practice? And we're a startup, right? So we have about 10 people at the company, and so I guess what's best practice for an organization at our size, and then kind of how to elevate that as we grow.
Very good question. Extremely important. Part of it is about risk analysis for a small company. So, I always start with, where is that employee coming from, right? Is it from a potential competitor, a company that is well established or not? So you look at what is the base, or is it a relationship that employee might have had that is likely to have created some intellectual property, some information that you should be aware of. In the case of where it's a regular employee that may or may not have, that didn't have any senior responsibility or management responsibility, you can go a little bit lighter on that person. But when it's an executive level or a senior level, I always made sure that I did ask for the employment agreement. That I first would ask, are you bringing anything from that company? And that's where it's a prohibition, right? You can't bring that employee cannot bring technology, proprietary information. So that always starts with like a training program. But I think it's a matter of where they're coming from. What level of risk do you see? If the degree of risk is higher, then you ask for more information. And in the employment hire, however you handle that, and you can always have a clause or two that does require that employee to disclaim that they are bringing anything that is sensitive or may be considered a trade secret.
Great, thank you.
You're
Okay,
welcome.
we have another question.
Thank you. Hi, Dick. Thank you for that. I'm involved in supporting commercialization and sort of building collaborative frameworks for a variety of organisations here in Australia. The question I had was, you talked a bit about collaboration and having those sorts of frameworks between ASCA and it sounds like there are similar versions in the US. Is there a particular, I guess, collaborative framework or form of agreement that US investors and even sort of US government looks to when they sort of want to put these sorts of, technology accelerator agreements in place?
Well, there are I'd say elements that are pretty standard when you look at the points that I've talked about when it comes to intellectual property, when it comes to the innovation, process, when it looks at who ownership, right, jointly filed technology agreements per se are no, but there are a lot of checkpoints of what they want to see, and it depends on the nature of the investment and how involved that investor may be going forward, including are you considering them to be on a board position? But there is a basic template that I use, but I encourage everybody, to basically customize it. And it's a matter of hitting what is it that's unique to your business, and how well are you protecting that in your collaboration.